Limitation number 3, promissory estoppel, shield, not a sword. In Combe versus Combe, during divorce proceedings, the defendant promised to pay the plaintiff, his ex-wife, £100 per year maintenance. The defendant failed to pay. The plaintiff was in a better financial situation and did not pursue court proceedings for the money. However, several years after the divorce was finalized, the plaintiff brought an action for the arrears of £675. Is the promise enforceable? The plaintiff could not use promissory estoppel to create a cause of action. It was held that it can only be used as a defense to an action to enforce legal rights which have been waived. Therefore, the plaintiff would only be able to sue if she provided consideration for the promise. The plaintiff argued that the court held that she had provided consideration by not applying to the court to enforce the promise. However, the court found that her forbearance was not done at the defendant's request, and therefore it was not consideration for his promise. Remember Lord Denning's words, "The principle does not create new causes of action where none existed before. It only prevents a party from insisting on his strict legal rights when it would be unjust to allow him to enforce them." Counsel in Combe versus Combe was credited by Lord Birkett with inventing the phrase, "Promissory estoppel can be used as a shield but not as a sword." Many students remember this catchy little metaphor, but it does not in itself explain the scope of promissory estoppel. You need to ensure that you understand that the promissory estoppel is a shield because it can block actions on pre-existing obligations where there has been a fresh promise, unsupported by consideration to modify or discharge the pre-existing obligation. In this way, the landowner Hughes was not allowed to rely on his strict legal rights under the lease because these had been modified when he indicated that the time would stop running against the railway company during the negotiations. Similarly, the tenant in High Trees sought to use estoppel defensively against the claim by the landlord based on his strict legal rights under the lease. The difference being that the landlord's claim for the full rent after the war succeeded in this case, because the estoppel only extinguished his strict rights for the duration of the war. Promissory estoppel cannot be used aggressively as a sword in the sense that it cannot be used to enforce a standalone non-bargain promise to pay, let's say, £100. The promisee must therefore wait to be sued on a pre-existing obligation and then use promissory estoppel as a defense. That is, as a shield. Under English law, promissory estoppel mitigates the harshness of the rule that a promise to modify or discharge a contract must be supported by consideration. But it goes no further than this as things stand at the moment.